Hey everyone, Brian Ponder, Brian the credit lawyer. So, question today was, my dispute was verified, now what? So that's a good question. And once again, the lawyer answer is it depends. If you come to me with the verified dispute, and by the way, verified disputes, we must be talking about credit reporting disputes, right? Because you don't dispute, you can also dispute things with the original creditor or debt collectors. However, those don't come back verified. They come back, for example, with original creditor, they may send you some credit card bills, okay? Or with the debt collector, verification means they're going to send you back the name and address of the original creditor. But that's not what we're talking about when something comes back verified. Those don't come back verified. When you dispute a trade line, whether it be a debt from a debt collector or original creditor, like a credit card company or bank, sometimes those will come back verified. Alternatively, they'll come back either deleted or modified, updated. Modified means updated. So updated may mean they make some change. Now, I've seen a lot of things that say updated, but there's no update, but that's another story. Today we want to talk about when they come back verified. Verified means that the Equifax, TransUnion, Experian made no change. They left it just like it was, like you didn't dispute it. That's a big problem because your goal in repairing your credit is to get it deleted, right? Or it may be a situation where you want it updated to be accurate or complete. So back to the question. Let's try to make this short because it's really a loaded question. Everything can be a loaded question, but we want to make things as efficient as possible. So it came back verified. What do you do? Well, if you come to me, my first question is, I want to see your dispute. A lot of people are um, using or doing disputes that are not applicable to their dispute or not sufficient for their dispute. And what do I mean by that? Well, applicable. Well, keep in mind, by the way, the law that governs disputes to consumer reporting agencies, which everyone incorrectly calls credit bureaus, is the Fair Credit Reporting Act, FCRA. The FCRA is a complex law, but it can be simplified. Basically, it says everything that's reported, these consumer reporting agencies like Equifax, for example, when they prepare a report, when they furnish and publish this information, well, they don't furnish it, but they furnish it to third parties. When they publish it, which means give it to others, it has to be completely accurate. Everything in there has to be accurate and complete. So those are the two things that you're looking for. You're looking for accuracy and completedness. If there's anything inaccurate or anything incomplete, well, you get to dispute that. You get to dispute it on the basis of it being inaccurate and or incomplete. So when I say some of the disputes are not applicable, well, your dispute has to be tailored or should be tailored to what the issue is. Okay, so you can't, be careful using canned disputes to consumer reporting agencies. Now, to debt collectors, you can use canned or templates very easily because you simply are telling them what to do, and if they don't do it, what you're going to do. It's really simple. But to consumer reporting agencies, you have to take a very fine-tuned approach, I would say. So the first thing I would look at is your dispute. Was your dispute on point with the issue, or was it tailored to that particular problem? A lot of people may go online and find stuff that says, oh, just say it's not my debt. Well, you have a 10-year, 10-month payment history, and all of a sudden you're saying it's not your debt. Um, you know, that's that's not a very smart approach. Um, by the way, a not your debt dispute would be it's inaccurate, right? meaning that the consumer reporting agencies are inaccurately saying that you're responsible for a debt when you're not. Be careful with those, because now the only thing that consumer reporting agency needs to do is, basically verify that it is your debt, and that may be done by the furnisher by clicking a button saying, yeah, this is their debt. Look, they've been paying on it for this long and never said there was a problem. So you want to custom tailor your dispute. So if a dispute like that comes back verified, I would recommend redisputing and being a little bit more specific and tailor your dispute to the issue. So let's give an example. Let's say if it's a credit card bill, right? And that credit card bill, which many times can reflect, well, first of all, it's a lot of stuff that can go wrong. It can be inaccurate by giving the wrong amount due, right? Maybe it didn't update properly. So your dispute could be, I don't owe $1,000 to Chase. Maybe you paid the bill, and as of the time of your letter, you owe $800, right? So that's an inaccuracy. The law doesn't provide them a window of time to get it right. So if they're publishing something about it and when you dispute it's incorrect, I'm just giving you an example, okay? Don't think that's the only twist. Let's look at another twist. Perhaps I've seen issues where you have mortgages that foreclose, they don't show a balance, they have a whole lot of late payments, and where it says balance, it just says nothing. Well, that's incomplete. You can dispute that mortgage on the fact that it's incomplete and get it deleted. Um, uh, you know, I've seen it done. Student loans, they're known for incomplete credit reporting. They won't show a balance. The student loan will be transferred to another servicer. The balance won't update. They just leave it blank. Well, that's incomplete. Same thing with payment history. If every month their reporting is not showing anything, that could be incomplete. It could say you were late 1 month, but you were not. Well, that could be considered inaccurate, right? So tailor your disputes. It takes more time. I know it's easy to just say, oh, it's not mine, but it's also easy for the Consumer Reporting Agency to legally come back and verify it without penalty, right? Now, let's say, well, Brian, my dispute was very custom tailored. I know what you're saying already, and this is nothing new to me. Well, if it still came back verified, my question is, well, my next suggestion would be write them back and ask for method of verification if they didn't give it to you already. Meaning you want to know who they contacted to quote unquote verify this information. Now, under the FCRA, they have to tell you that. If they don't tell you that, that's a violation as well. So try to get that information. Now, if you're looking at this video before you even do a dispute, first of all, tailor that dispute, okay? Don't do a canned dispute. When I say canned, I mean just template it. You can have a template for a certain situation. So if you find a template that talks about incomplete balance reporting or, no balance reporting, then you can use that letter. But, don't just use one letter for every situation. That's what I mean by that. A lot of people ask me for templates, but again, there are so many situations where the letter needs to be tailored. Now, I will, recommend a book where you can find a whole lot of tailored templates, but I personally don't write or have not written any templates to sell or give people regarding consumer reporting agency disputes, because there are so many ways you can do it. Actually, I think I did do a free inquiry removal letter. But again, there's so many letters, but I will give a recommendation. Otherwise, when people come to me, I can help them custom tailor their own dispute. But again, I'll give a recommendation. But this video is really about what to do when something is verified. And again, one, look at the dispute, make sure it was custom tailored. Two, request a method of verification, which under the Fair Credit Reporting Act, the Consumer Reporting Agency has to provide that to you, just like they have to reinvestigate once you do a dispute. Okay. Now, if the if the Consumer Reporting Agency already told you who they verified it with, then you can consider foregoing the method of verification step 2. You might want to go to step 3. Step 3 would be additional disputes, right? And when I say additional disputes, I don't mean send in that same dispute. Review the trade line for any other issue, or look at that same issue and make sure your letter says what it needs to say to attack that issue. If your letter says what it needs to say, or if there's nothing else to be attacked, then perhaps you can skip that step. And when you skip that step, I think it's time to consult an attorney. Let someone look at it. Let someone review the issue and give you further advice, which may be you may have a lawsuit that you could file. Or you may have missed something and may have another dispute that you could do that would be something different and may produce a different result, which is a deletion or modification of the trade line. So that would be, I would say a step 4 option. Now, if you're doing step 4, who can you contact? Well, make sure you contact a consumer lawyer that deals with these issues. My law firm obviously deals with these types of issues, and you'll see my contact information. So if you have gone through all of that and still got no deletion, contact a lawyer, contact my firm, get a consultation, get some advice. What I don't recommend is continually redisputing using the same letter. Okay, if you're going to redispute something, you should not be sending the same thing. You should be reapproaching it in a different way. Otherwise, when I say the consumer reporting agencies can deem what you're sending as frivolous, meaning we've already decided this dispute and you're just resending a dispute. So you don't want to get that result, because that's a waste of dispute at that time, and a waste of your time. Again, our goal is to be as efficient, or your goal should be, our goal, meaning you, me, whoever's doing it, is to be as efficient as possible. So custom tailor that dispute to the Consumer Reporting Agency. If I were you, in your dispute letter, I would go ahead and ask for verification. I'm sorry, not verification, but a method of how they investigated this thing, if they deem it to be verified. Should they deem it to be verified. Or you can just wait and see what happens, and then once you get a verified response, write them back and request their method of investigating your dispute. Okay? And again, after you custom tailor it, see what happens. You should get a deletion. If you don't, look at it. There are likely several inaccuracies or incomplete issues. Maybe approach another dispute at another issue. That doesn't work, get an attorney to review it and see if you missed something. These things seem very simple, but a lot of times you may miss something. Someone may see something you didn't, so get someone else to review it, and then reapproach it. By all means, don't give up, because again, credit reporting is a voluntary system. These consumer reporting agencies are making millions of dollars, I think, a day off of you. They make billions each year selling your information. It's a private market, so don't give up. They're exploiting your identity for their own profit. The least they could do is make it favorable to you. So any questions, feel free to comment below. You'll see a link. Like I said, I'll provide a link for you that need want a recommendation to some custom tailored templates, I'll recommend that. This is not my book, but I'll give you a recommendation. Obviously, if you want to contact me to help you with something directly, you can do that. I'll put my information below. But anyway, good luck, and I hope that was helpful. Leave comments, and talk to you soon.